Good morning, members of the panel. My name is Seah, and together with my co-counsel, Mr. Ramesh, we represent the appellant, Mr. Antonio Fortuna. I'll be addressing the first two issues on appeal for 10 minutes, namely whether Mr. Fortuna's statement of appeal is admissible, and thereafter whether his refusal to surrender his mobile phone to the respondent was lawful, together with the potential legal consequences that may ensue. Mr. Khanna would address the panel on the remaining two issues for 10 minutes. We respectfully reserve 1 minute for rebuttal. Members of the panel, we do acknowledge that certainty is a cornerstone in procedural matters before this court. However, overemphasis on certainty must never come at the expense of fairness and justice, particularly where a party has taken all reasonable steps to comply by rules and yet is only thwarted by forces beyond their control. Today, this panel is faced with two options. This panel can choose to excessively enforce rules that results in unfairness, or they can choose to respect the fundamental values of natural justice, such as the opportunity to be heard, and ensure that procedural formalism does not eviscerate real access to justice. Turning to the first issue, Mr. Fortuna maintains that his statement of appeal is admissible and respectfully requests that a time limit be reinstated given the unforeseen and non-negligent technical failure experienced by his legal team. Firstly, the statement of appeal was filed before the expiry date. Applying Rule 49 of the CAS Code, it stipulates that a subsidiary time limit of 21 days from the receipt of the decision appealed against is 21 days. We submit that the date of receipt in that case is 2nd April and not 31st of March, as the respondent may allege. Under Rule 49 of the CAS Code and interpreted by the 2013 CAS case of Dominic and Jatko, the word decision in receipt of the decision refers to the full grounds of the decision and not merely the decision itself. While the bare decision was indeed published on 31st of March, we have to consider the dangers of submitting an appeal without fully knowing the decision. Firstly, filing an appeal is not free. It requires the non-refundable fee of CHF 1,000 as noted in Rule 64 of the CAS Code. Aside from that, on a more practical perspective, Mr. Fortuna needs to first consider what exactly he is appealing. Without the full grounds of decision, he could possibly be lodging a frivolous appeal, which is explicitly discouraged by the CAS as noted by the commentators Mavometti and Reed under Rule 48.
Counsel, your opposing counsel will submit the receipt is 31st March and that it was an appealable decision and that it need not have full grounds. What is your response to that it does not need to be full grounds?
Thank you for the question, Mr. Arbitrator. We are considering this question in more of a practical perspective rather than a legal perspective. In our case, you have to consider that lodging an appeal in the first place requires a decent amount of effort and requires them to understand what they are even appealing against. The sole bare decision that the FIFA Appeal Committee is rejecting Mr. Fortuna's appeal is not sufficient for Mr. Fortuna himself to appeal to the CAS. And notably, by Mavometti and Reed, the CAS does not like frivolous appeals. Without the full grounds of the decision, it is possible that Mr. Fortuna is lodging a frivolous appeal without knowing the full merits of why the FIFA Appeal Committee decided to reject his appeal in the first place. And furthermore, Mr. Fortuna had also attempted to meet this deadline. Rule 32 of the CAS Code dictates that time limits are respected if communications are sent before midnight. And if I could turn the bench to para 27 of the record.
Yes.
Mr. Fortuna had attempted to file the statement of appeal via email on 23rd April 23:45 at Iridonian time, placing a communication squarely within the prescribed timeline. And last but not least, the filing failure was caused by an unforeseen external impediment. We are requesting a reinstatement in this case, not a time extension, as respondent counsel for the respondent may allege. This is a remedy available when a party was prevented from complying due to an unforeseen impediment which makes compliance impossible through no fault of their own. We submit.
Counsel,
Yes.
and I know you were just getting to your submission, but would you say that the appellant had acted promptly, given that they had not submitted the appeal brief on time in the first place? I know I'm jumping the gun a little bit, but
No worries, Mr. Arbitrator. On that point, we consider the appeal brief to be a subsidiary document to the statement of appeal itself. Firstly, we do not know the original contents of the statement of appeal. As noted in case law, if the statement of appeal is considerably detailed already, an appeal brief is not necessary and only serves to further clarify what was mentioned in the statement of appeal. And as noted by the commentators Mavometti and Reed, and in the 2023 Swiss Federal Tribunal case of Colombian Professional Football and Brazil, ordinary procedure is more flexible when it comes to the time limits of subsequent written documents, which is precisely what the appeal brief is. And turning back to the statement of appeal, the only reason why it was prevented, why the counsel for the appellant was prevented from sending it, was because of the cyber attack, which is clearly an unforeseen impediment. I note my time, and unless I may be of further assistance on the first issue.
just one question, counsel. We noticed that appellant filed the statement of appeal 15 minutes prior to the deadline, correct?
Yes.
So would this not sort of show a level of carelessness? Just want to hear your response.
Certainly. On a practical standpoint, we do acknowledge that we did file the statement of appeal rather close to the deadline, but we have to consider what we were appealing in the first place. As noted earlier, we cannot lodge a frivolous appeal, if not, the CAS wouldn't even consider our case in the first place. And crucially, we had filed the statement of appeal before the deadline. Even if it's 1 minute before the deadline, it is still before the deadline, and we need time to consider what we are appealing in the first place. Unless I may be of further assistance on the first issue, I'll now turn to the second issue. We submit that the decision of the FIFA Appeal Committee should not be followed and maintain that Mr. Fortuna's refusal to hand over the phone is lawful and justified by fundamental rights under the European Convention of Human Rights, hereinafter the ECHR. As noted in the 2018 ECHR case of Mutu and Pashtin, Article 6 of the ECHR can apply to proceedings in a case if it applies to, and I quote, the determination of civil rights and obligations of any criminal charge. The court had recognized that the suit against Pashtin involved a disciplinary procedure where the right to carry on an occupation was at stake, as Pashtin was to be suspended from playing for 2 years. Similar to our case, Mr. Fortuna is facing a possible 5-year ban, as noted in the FIFA appeal decision, which directly prevents him from practicing his own profession, which falls under a determination of civil rights, and hence Article 6 would be applicable to the proceedings.
Counsel, according to Mitu and Pechestein, isn't it true that Article 6 is only invoked when arbitration is mandatory, and is it mandatory in our case?
Thank you for your question, Mr. Arbitrator. Yes, we do submit that arbitration was in fact mandatory in our context. If I could first turn Mr. Arbitrator's attention to our bundle of authority, Article 14.1, subsection L of the FIFA statute, it directly applies to the Iridonian Football Association, who is a member of FIFA, and stipulates that all member associations are to comply with the duties arising from the FIFA statute. And the duty we're contending here is under Article 51, subsection 3 of the FIFA statute, which makes arbitration compulsory for any disputes that may arise. Therefore, reading both of these articles conjunctively under the FIFA statute, arbitration is compulsory in today's proceedings, and hence Article 6 of the ECHR is invoked. Turning now to the merits of the issue, we submit that Article 6 protects Mr. Fortuna from self-incrimination. Firstly, in the 1993 ECHR case of Funke and France, The appellant had refused to produce his personal financial documents, and the court said, Mr. Arbitrator, I note that my time has elapsed. If I may have 1 minute to wrap up my submissions.
Yes.
Thank you, Mr. Arbitrator. Crucially, the court in that case noted that the conviction was secured in order to obtain the documents that the appellant refused to give up. Similar to our case, compelling Mr. Fortuna, under the threat of sanction, to produce private data that could directly incriminate him in a concurrent criminal matter, which is filed by the Iridonian public prosecutors, is incompatible with Article 6 of the ECHR, which was noted in Funke and France to protect the right to a free trial, in which self-incrimination is a key component of Article 6. Secondly, Article 12.3 of the FDC thus expressly provides that any persons who do not respect the code are subject to punishment. We submit that Article 6 of the ECHR does take precedence, and this is an international treaty that bounds Switzerland and goes far beyond the confines of the Court of Arbitration of Sport itself. Unless I may be of further assistance on the final issue.
Just one last question, counsel. Why should we follow the ECHR over CAS jurisprudence?
Certainly, Mr. Arbitrator. I know that my time has elapsed, and I will quickly answer your question.
Yes.
Well, firstly, Switzerland itself is a member of the ECHR, and this is noted in the signatories to the ECHR. So therefore, that makes ECHR the law that bounds the country itself. And as noted in Mushtu and Pushtain, the CAS has to ensure that its decisions follows the rules followed by the general laws of the country. And as the ECHR forms the general laws of the country, i.e. Switzerland, and the CAS is bound by Switzerland jurisdiction, Swiss law to be exact, as its seat is located in Switzerland. Therefore, CAS has to ensure that its decisions follows and complies with the ECHR. Unless I may be of further assistance.
Thank you, counsel.
Thank you, Mr. Arbitrator. I'll now hand over my time to my co-counsel, Mr. Ramesh Khanna, who will address the remaining 2 issues on appeal. Thank you.
Good evening, members of the tribunal. My name is A. Ramesh Khanna and I act for the appellant, Mr. Fortuna, on issues C and D. I have 2 submissions for the tribunal today. Firstly, the anonymous witness statement and the anonymous email are not admissible. Secondly, Mr. Fortuna has not breached Article 20 of the FDC. Now, firstly, the CAS imposes strict safeguards before anonymous evidence can be relied upon. This was seen in the 2017 CAS decision of FC Khairat Almaty and UEFA, where the panel held that anonymous testimony is only admissible if 3 conditions are met. Firstly, there is a necessity of anonymity. Secondly, there's an identity verification by the panel. And thirdly, there is sufficient corroboration. An academic commentary by Mavromati and Reeb and commentary on the CAS code regarding Article R57 confirms that anonymity must be exceptional, justified by a concrete, objective threat. Now, none of these safeguards are met in the present case. The anonymous witness statement is based on unsubstantiated fears. The witness claims they fear intimidation because of rumors that Fortuna's father had criminal connections. However, the 2018 CAS decision, Wada and Sanyang, the panel held that speculative fears without objective evidence of danger cannot justify anonymity. Here, in the present case, no threats were made, no incidents occurred, and no supporting evidence exists. Thus, anonymity was not necessary under the Khairat Almaty standard. Furthermore, the witness's observations are weak, incomplete, and untestable. The witness observed the appellant stress the night before the match and heard him say, "Dad, stop pressuring me." But critically, the witness himself admits he could not hear the father's side of the conversation. And the 2009 CAS decision FK Pobeda and UEFA, the panel ruled that evidence cannot be cross-examined meaningfully because the context is missing. Thus, it could not satisfy the standard of proof required. This was also the case in the 2020 CAS decision of KF Skanderbrew and UEFA, where anonymous uncorroborated observations were held insufficient in match-fixing cases. Now, the evidence here demonstrates stress that Mr. Fortuna was under. However, it was not manipulation, and this claim is wholly uncorroborated. Now, moving on to the anonymous email, it is even weaker in that it's unauthenticated digital hearsay. Now, the email alleges that Fortuna's father received 50,000 dodgy coins and attaches a WhatsApp screenshot saying, "Look the crook," acknowledging the receipt. But the sender states, and I quote, "I will not reveal my identity and cannot provide more information." Now, under the 2011 CAS decision of Alejandro Valverde and Connie, digital evidence must be authenticated through metadata, forensic analysis, and verified origin. Here, there's no metadata, there's no verification of the wallet ownership, and there's no forensic confirmation of the screenshot, and there's no link between the alleged payments and the appellant.
Counsel, I have a question. So, since there's no alleged link between the made payments, how are we sure that this wallet belongs to Mr. Fortuna's father? And what are the proofs we have?
Indeed, Mr. Arbitrator. So, with regard to the verification issue, what we are claiming is that whatever wallet that has been seized by the public prosecutor, that is definitely Mr. Fortuna's father's wallet. We're not contending that. However, what's at question here is whether the wallet that was involved in the transaction that is evinced by this WhatsApp conversation, whether that wallet belongs to Mr. Fortuna is the question to be answered. And this at the present moment has not yet been proven. Thus, given that the burden of proof lies on the prosecutor and the respondent today, the respondent cannot rely upon this evidence to further their case, because as it stands, it cannot be verified that the wallet that has been seized was indeed the wallet that was involved in this transaction. And this is supported by the fact that even the Iridonian prosecutor simply states that the father provided access to his Dogecoin wallet, not that any illicit transfer had actually occurred. So as it stands today, this has yet to be proven. And as Blackshaw Sports Law notes, anonymous digital submissions are the weakest form of evidence under the CAS regime. Thus, this should also be taken into consideration when looking at how much weight to provide this evidence if it is indeed admitted. Now, finally, the comfortable satisfaction standard cannot be met. Match manipulation allegations require the heightened standard of comfortable satisfaction. This was indeed what was written in opposing counsel's written submissions, and we agree with it. Anonymous evidence cannot meet this threshold unless identity is verified, motive can be tested, and testimony is corroborated. Now, none of these prerequisites are met. Even if admitted, the evidence carries no probative value. And the authority for this is the 2010 CAS decision of Oleg Orkyov and UEFA. Now, if members of the tribunal have no further questions regarding the first issue, I would like to move on to issue D.
Just one question, counsel. So I'm looking at the FIFA's decision, paragraph 30. States that the police or that the authorities had it might be another paragraph, but the investigators confirmed that the Fortuna's father had given access to the wallet. What is your response to that?
Sorry, Mr. Arbitrator, could I understand which page you're referring to? Yeah, so this paragraph here.
Yeah, go on.
Understand.
Yeah.
If members of the tribunal are with me, this paragraph here is indeed representing what I had just stated, which is that Fortuna's father had indeed given the public prosecutor access to his wallet. However, Mr. Arbitrator, this does not go towards proving that the illegal transaction that has been evinced by the WhatsApp chat involves Mr. Fortuna's father's wallet. That could have been any other wallet, because the identity of the parties involved in that conversation cannot be proven by forensic analysis or metadata. So all that paragraph 36 goes to show is that Mr. Fortuna's father's wallet is under investigation. But as it stands today, there's no proof that it was involved in any illicit transaction. Thus, it is of no value to the current proceedings.
Okay, thank you, counsel. Yes, paragraph 36. Yes, you're correct. Yes.
No worries. So, regarding issue D, Article 20 of the FIFA Disciplinary Code has not been violated. Properly construed, Article 20 requires proof that the appellant directly or indirectly by act or omission unlawfully influenced or manipulated the cause, result, or any other aspect of the match, or conspired to do so. Now, the legal framework requires a high standard for match fixing under Article 20. CAS has consistently held that allegations of match fixing must be proved to the standard of comfortable satisfaction, which is higher than a mere balance of probabilities, however lower than a reasonable doubt. Now, this is clear from the 2010 CAS case of Oleg Orkyov and other precedent cases. Now, in those cases, the sanctioning bodies relied on a convergence of strong evidence, intercepted calls, financial flows, witness statements, and in Orkyov, even findings of the state courts. An academic analysis of CAS match fixing jurisprudence emphasizes that mere suspicious betting or poor performance alone cannot meet this threshold. So, members of the tribunal, the core issue here is whether or not, beyond the evidence that the opposing counsel seeks to admit, it seeks to rely on, are there other corroborative factors in this mosaic of evidence? And here, in the present case, FIFA relies on a betting pattern report by Genius Report and anonymous evidence that we have already challenged under issue 3. The mere fact that the appellant's crypto wallet was investigated is of no value. Thus, taken together, this falls far short of the comfortable satisfaction under Article 20. Now, moreover, the Genius Sports report evidences suspicion, not manipulation by Fortuna. The Genius Sports Integrity Report clearly explains that performance analysis is based on our opinion only, and that the report is designed to highlight incidents for further investigation. I note that my time is up. Could I request for 30 seconds to sum up my submissions? And the report is designed to highlight incidents for further investigation, not to assert that any individual is definitely involved in impropriety. And this is distinguishable from the other precedent cases that opposing counsel has relied upon to state that when there is objective evidence, anonymous reports can be used to prove guilt. Thus, we conclude that in this regard, the evidence that is present, that is admissible, even if it is admissible, is of low probative value to prove that Article 20 has been breached.
I have one question, counsel. What is your response to respondents' argument that there was a witness from the Iridonian team, a player on the team itself, who I believe had heard a phone call, right, the night before, plus that in conjunction with the refusal to hand over a phone, along with some of the other, so to speak, weaker evidence? How do you reconcile that with the standard of proof of mere comfortable satisfaction? Because it would seem pretty strong if an actual witness on the team heard it.
Understood, Mr. Arbitrator, and I referred to your last statement, which is if indeed a teammate within the team had heard it, it would be strong evidence. However, the very issue that presents in front of us today is that we cannot confirm this if the evidence is untested. The fact that we cannot cross-examine this testimony makes it highly unreliable and prejudicial in that, for all we know, all this tribunal could know, as long as it is not verified, it could be blatantly fabricated. And to answer the second part of your question regarding the appellant's alleged non-cooperation, as my co-counsel had iterated earlier, there have been investigations ongoing regarding the same issue by a public prosecutor. So if the appellant were to have handed over his phone, that would have resulted in him prejudicing himself in separate proceedings. And given this crucial fact, it was not wrong of him nor non-cooperative of him to have not handed over his phone, and this has been supported by CAS jurisprudence that my co-counsel has iterated earlier on.
Thank you, Counsels.
The best. Oh yeah. So thanks. Thank you.
Hold on, I think I have to record.
Yeah, it's recording.
Is it recording?
Yeah.
Wait, Brandon, so are you good if I ask you questions?
Sure, yeah.
For Mark, I'll just ask you the question that we prepped.
Okay.
Okay.
Good evening, members of the panel. My name is Brandon Zhang. With me is my co-counsel, Mark Maxwell Peter. We appear on behalf of the respondent, the Federation International de Football Association, FIFA. I'll speak for 9 minutes and respectfully reserve 1 minute for rebuttal. This case is about integrity of the sport of football. Sanctions and compulsory cooperation is essential to maintaining the image and integrity of the sport. There is no place for corruption and the manipulation of match fixing. I'll speak on 2 issues. First, the procedural issue on the appellant's statement of appeal. Then I will speak on the second substantial issue of whether the appellant's refusal to hand over the phone was unlawful. Turning to the first submission, we submit that the statement of appeal filed by the appellant, Mr. Antonio Fortuna, is inadmissible for 3 reasons. First, the time of the receipt shall begin on 31st May 2026. As the appellant, Mr. Fortuna, had the opportunity to obtain knowledge of the decision. Second, the decision of 31st March is an appealable decision. Third, the cyber attack does not meet the threshold requirement under Article R57 of the CAS Code. Turning to the first argument, according to Anthony Ragozzi, in the book Arbitration in Switzerland commentary to Article R49 at page 498, I quote, "It suffices according to the current jurisprudence that the addressee had the opportunity to obtain knowledge of the decision, whether or not the addressee had actual knowledge." In the present case, if I may direct the panel's attention to paragraph 23 of the record, here the appellant had hired legal counsel and had advised him that any investigation could prejudice his right. However, at paragraph 22, members, at paragraph 26, the fully upheld decision was released on 31st March. And at this particular time, it had been months, and the appellant, therefore, his legal counsel would have had the opportunity to obtain knowledge of that decision. And therefore, the relevant day of receipt, which triggers the statutory 21-day time limit, begins on 31st March 2026.
Counsel, I have a question. In response to the counsel for the appellant's earlier argument that it will be more practical to submit an appeal with the grounds of the decision, what do you have to say in regards to that?
Sorry, could you rephrase the question?
Earlier, the counsel for the appellant had alleged that the time of the receipt should only be considered to be the 2nd of April, as he has the full grounds of
Right,
decision, and
right.
he noted a more practical standpoint with regards to an appeal. What is your response to his practical standpoint?
Thank you, Mr. Presiding Arbitrator. We submit that for two reasons. One, that decision on 31st March is an appealable decision. According to jurisprudence, it contains a sanction, a legal decision which affects a legal party. And two, it has also been held in case law that a appealable decision need not to have full grounds for appeal. And therefore, for example, in the 2019 Qingdao Junun FC versus FIFA decision at paragraph 61, the panel recalled that it is constant case jurisprudence that a decision in principle does not need to contain grounds in order to be appealable.
On that note, the appellant had also raised another case law, Dominic and Jacko, if I earlier remembered, stating that Rule 49 has been interpreted, where the word decision in Rule 49 has been interpreted to mean the full grounds of decision. So, which case law should the CAS be following?
Well, Mr. Arbitrator, it's important to note that CAS case law is not stare decisis, and accordingly, on a case-by-case basis, the panel will need to make its decision. But we submit that because it contained a sufficient ruling in paragraph in the FIFA's appeal committee, i.e. that the 5-year sanction ban and the CFHF $100,000 fine meets a sufficient requirement threshold to at least have the appellant aware of the legal decision in that appeal. Thank you. Turning to the next argument, appellant had argued that the cyber attack was an exceptional circumstance, and we submit that it is not exceptional for two reasons and does not meet the threshold requirement under Article R56, which is a disjunctive reading, i.e. it requires 4 of the limbs to be satisfied here. And in particular, it does not satisfy limb 1 or 3. Here, the objectively prevented from acting on time has been held in the case of PFC Live versus LLC, PFC versus UEFA at paragraph 89. It was held that the panel notes that objective obstacles caused by official holidays and the inconvenience of sending documents by courier, the delay by the courier of a few days, did not prevent the appellant from complying with the deadline, and held that the deadline for the appeal had been missed and rejected the appeal as inadmissible. And secondly, if I could direct the panel's attention to paragraph 30 and 29. Here we submit that the Mr. Fortuna's legal team had waited 2 days to reach out to the CAS at paragraph 29, line 2. Appellant's counsel reached out to CAS on 28, 2 days later, after they had received the IT email. And we submit that this 2-day period does not fulfill the requirement under the limb 3 of R56. And therefore we submit that the cyber attack is not an exceptional circumstance, but more importantly, on the last point, members of the tribunal, if I could point your direction to paragraph 30, line 3 and 4. Here, the email servers had recently been subject to an attack, which may have disrupted outgoing emails without necessarily generating delivery error messages. And it is our submission that there is no causal link here. That's not been actually proven whether the relevant time had affected the emails, and even if there were, did not necessarily mean that there was error messages delivered. And as well, the appellant would have had the opportunity to check its email box, click on send to double check whether that message had indeed been sent.
Counsel, I have a question about the submission you made regarding the 2-day gap between 26 and 28. Notably, on the 26th itself, it is a Sunday, and naturally, I wouldn't think that the CAS officers would be open on that day. So essentially, the only date in contention here should only be a 1-day gap. Couldn't it be said that the council was busy addressing the issues that may arose from the cyber attack, and therefore they needed a day to address the issue and only could find a time the next day to address the CAS regarding the fact to ask the CAS whether their appeal has been submitted? Wouldn't you agree with that possible conclusion of the facts?
Thank you, Mr. Presiding Arbitrator. With respect, we disagree. Article R56, Lim 3, the party immediately act as soon as he or she is able to do so. And therefore, we submit that immediately means as soon as possible after receiving the IT email, that would mean the word immediately, and therefore does not meet Lim 3.
Counsel, I have a question regarding the analogy that you made with the courier service. The case where you said that courier delays will not be recognized. Could I get you to expound on what was the underlying principle for why the tribunal rejected that as not an exceptional circumstance, and how that is analogous to the current situation? So 2 parts to the question.
Okay. In that particular case, the appellant had cited the late statement of appeal for 2 reasons. Because it was the official holidays and there were some delays with the holidays, but also there was also courier delays of, I believe in that case, 5 to 10, 15-ish days, around that time frame. And accordingly, the panel in that case stated that objective, I quote, objective obstacles which made it difficult to comply with the deadline, in particular the official holidays during the deadline of appeal and the inconvenience when sending documents by courier were not of a nature to prevent the appellant from complying with the deadline. And in our case, how it relates is that this is an analogous situation to our case. Email server can be similar to the courier service in this case, in which there is some inconsistencies between the delivery time, whether that's a cyber attack, or that's a holiday, some sort of holiday impacting, or the delivery service of the courier service itself. And therefore, we submit that it is reconcilable on those bases. If there are no further questions on issue 1, I will proceed to issue 2. The appellant had refused to hand over his phone when requested by FIFA. We submit this is unlawful for 3 reasons, and as a result, the court may, or the FIFA Appeal Committee may impose sanctions. First, the applicable standard of proof is mere comfortable satisfaction and allows adjudicating body to base its decisions on natural inferences. Second, the evidence infers that the appellant was involved in match fixing. And third, the privilege against self-incrimination cannot be invoked. Turning to the first argument, CAS jurisprudence has recognized that the applicable standard of proof is comfortable satisfaction. And here the parties are voluntarily submitted themselves to the sports governing bodies provisions, and in the 2017 CAS decision of Jerome Valk versus FIFA at paragraph 277, the panel held that the appellant violated articles, the duty to cooperate and match fixing for his failure to produce documentary evidence and held that that was a violation. And similarly, in our case, if I may direct the panel to paragraph 20, here Mr. Fortuna refused to cooperate on 2 accounts to submit his mobile phone and provide mobile phone data on 2 accounts. And therefore, under Article 12, subsection 2 and 3, this is a breach of the FDC, and it gives this court under Article 8 of the Swiss Civil Code to base its decision on natural inferences. And this is because CAS recognizes that in match fixing, corruption is by its nature concealed, as the parties involved will seek to use evasive means to ensure they leave no trail of their wrongdoings. And in conjunction with Exhibit 2, Exhibit 3, Exhibit 4, and Exhibit 6, the appellant Mr. Fortuna was heard on his phone the night before the match, arguing with his father, in which his father had asked him to do something. And on the totality of the circumstances, therefore, we submit that this gives rise, the refusal to cooperate and provide the phone, in conjunction with the evidence, gives the panel the right to inference under Article 8 of the Swiss Civil Code.
Counsel, isn't it earlier counsel for the appellant had mentioned Article 6 of the ECHR and saying that if we do agree that Article 6 of the ECHR does give the appellant the basis to reject handing over his phone, what would your answer be to that?
Thank you, Mr. Presiding Arbitrator. May I hear the question one more time briefly?
To phrase it a bit more clear, Article 6 of the ECHR, as construed by the appellant, notes that this gives Mr. Fortuna the right to refuse to hand over his phone because he's fearful of self-incrimination. So how do we reconcile that with Article 12 of the FDC, as you have mentioned?
Thank you. We submit that the privilege against self-incrimination cannot be invoked for 2 reasons. First, the privilege against self-incrimination is a criminal procedural safeguard and thus is not applicable to disciplinary proceedings per se. And second, individuals, Mr. Fortuna voluntarily submits to the rules and regulations of a sports governing body, which has limited investigative powers, and therefore the panel in its jurisprudence recognizes that compulsory cooperation is permissible and essential to maintaining the image and integrity of the sport.
Counsel, just a quick question. Can you give me